Merci beaucoup. Alors, bonjour à tous. Good morning. Merci de vous joindre à moi aujourd'hui. Et je vous remercie de l'intérêt que vous portez à la Cour suprême du Canada et à notre système de justice. J'attends toujours avec impatience cette occasion de m'entretenir avec les médias et les journalistes, ici et en ligne, et bien entendu, de répondre à vos questions. My colleagues and I appreciate the work that you do. When covering the Supreme Court, journalists inform the public about our work, activities, and the Court's crucial role in Canada's democracy. Many of you also bring important legal issues to light, such as the underfunding of legal aid, high legal fees, court backlogs, delayed hearings, and judicial vacancies. While there have been a few federal judicial appointments in recent weeks, the number of vacancies hovers at around 80 across Canada. At a recent meeting of the Canadian Judicial Council, a significant portion of our discussions focused on the impact of these vacancies on our courts and judges. Some courts have been required to operate for years with ongoing vacancy rates of 10 to 15%. It is not unusual to see some positions remain vacant for many months, and in some cases for years. Appointments to the key offices of Chief Justices and Associate Chief Justice are also made very slowly. These empty positions have a significant impact on the administration of justice, the functioning of our courts, and access to justice for the public. They exacerbate an already alarming situation in some courts that are facing a critical lack of human and financial resources. Together, Canada's Chief Justices decided to raise these concerns at the highest level of government. En février 2018, certains d'entre vous se rappelleront que j'ai parlé publiquement de la nécessité de remanier le système des plaintes relatives à la conduite des juges. J'ai qualifié les procédures existantes de dépassées, lentes et obscures. J'ai également dit que bien que les Canadiens s'attendent à la transparence et à la responsabilité, nous continuons d'appliquer des modèles d'administration judiciaire des années 70. Le Conseil canadien de la magistrature ne peut modifier ce processus lui-même. Seule la législature peut le faire. J'ai donc été très encouragé en 2019 lorsque le gouvernement a commencé à réagir en discutant de réformes. Le projet de loi C9 propose un processus transparent et efficace pour traiter les allégations relatives à l'inconduite des juges de nomination fédérale. Un processus équitable à la fois pour les juges et pour les plaignants. Il y a eu beaucoup trop d'enquêtes publiques qui ont duré bien trop longtemps et qui ont coûté bien trop cher. Elles surchargent également nos tribunaux fédéraux qui sont débordés. Les contribuables canadiens sont obligés également d'assumer les coûts de ces enquêtes, y compris ceux encourus par le juge qui est visé. Malheureusement, et je pourrai en parler un peu plus tard, le projet de loi C9 est toujours devant le Parlement. Now, I expect many of you will have questions for me about Russell Brown's decision to retire from the Supreme Court. I would like to remind the public that the allegations he was facing at the Canadian Judicial Council had nothing to do with his work as a judge. Justice Brown had been absent from the court since February 1st, while the Canadian Judicial Council reviewed a complaint against him. Upon receiving the complaint, I called Justice Brown, and he agreed with me that the only course of action would be for him to stay away from the court pending the resolution of the complaint. The court confirmed his absence about 2 weeks later, on February 17th. As you know, although I chair the council, I have no role whatsoever to play in the investigation process. The Supreme Court of Canada has continued to serve Canadians in rendering independent and impartial decisions on questions of importance to the public. All 8 of us have heard cases, rendered judgments, and decided applications for leave to appeal. For those of you who have asked about sitting with 7 or 5 judges, I can assure you that this is a normal practice and provided for under the Supreme Court Act. For example, throughout the years, in 2012, the court sat with a panel of 7 on 48 times. In 2019, it sat with a panel of 5 on 12 occasions and with a panel of 7 on 20 occasions. With Justice Brown's departure, the court now looks forward for the Prime Minister to exercise promptly the necessary care and consideration in appointing a new Justice of the Supreme Court of Canada. J'aimerais maintenant parler du travail de la Cour suprême au cours de la dernière année. Selon moi, l'événement marquant a été son 2e voyage à l'extérieur d'Ottawa pour entendre des causes et échanger avec le public. La visite à Québec en septembre a connu un franc succès. Des centaines de gens ont assisté à 2 audiences sur des affaires ayant pris naissance dans cette province. Vous vous souviendrez, le dossier sur le cannabis, la production à la maison résidentielle, et ainsi qu'un dossier portant sur l'alcool au volant. Décisions qui ont depuis été rendues. La Cour a été l'hôte d'un événement public qui a attiré beaucoup de monde, et les juges sont allés à la rencontre des étudiants dans les écoles secondaires de la région et à l'Université Laval. For our newest colleague, Justice Michelle O'Bonsawin, the hearings in Quebec City occurred just 12 days after her swearing in. Her appointment was made effective on September 1st, after the retirement of our good friend and colleague, Justice Michael Moldaver. For years now, I have told you about the importance of diversity on the bench of the Supreme Court and every other court. More and more Canadians are seeing themselves represented on the bench. This can only serve to build more confidence in the justice system. The court will continue to hear cases in different parts of the country. They are one of several ways the court demonstrates its commitment to transparency, accessibility, and the principle of open courts. Recently, I was delighted to hear Nova Scotia Chief Justice Michael Wood announce that the Court of Appeal will sit outside Halifax in 2024 with a visit to Sydney. Internationally, la Cour de cassation et la Cour constitutionnelle de France, le Conseil constitutionnel de France, have also started to take the court on the road and to the public. À Ottawa, la Cour suprême est maintenant réouverte au public. Personnellement, je suis toujours ravi de voir des membres du public et des journalistes présents dans la salle d'audience lorsque nous y entendons des causes. Les visites guidées ont également repris sensiblement au même rythme qu'avant la pandémie. En mai, par exemple, 6 000 personnes ont visité la Cour, ce qui dépasse notre total du mois d'août 2019. Pour ceux et celles d'entre vous qui se demandent quand le banc des juges reprendra sa configuration habituelle, sachez que mes collègues et moi serons de nouveau assis ensemble sur une seule rangée au début de notre session d'automne prochain. Plus tôt cette année, la Cour suprême a publié la 5e édition de son rapport annuel intitulé « Rétrospective annuelle ». Il informe la population canadienne au sujet des travaux et des activités des juges et du personnel de la Cour. Il renferme également une multitude de statistiques utiles. La Cour a rendu 53 jugements en 2022 et 65 % de tous les appels concernaient des affaires criminelles. Si vous surveillez la fréquence à laquelle les juges de la Cour s'entendent sur tous sur une décision, sachez que 55 % de leurs décisions ont été unanimes en 2022, soit le niveau le plus élevé depuis 2016. Depuis le début de l'année 2023, 9 décisions sur 16 ont été rendues à l'unanimité. For those who want more recent news about the work and activities of our judges in and outside the court, I invite you to follow us on social media. That is where we also share educational and historical information and try to answer emerging questions, such as how often the court sits with 7 or 5 judges. A graphic with that information has just been posted last month. We strive to have an open and transparent court, encourage others to do the same, and learn from them. Earlier this spring, I met with court communications officers across Canada, who gathered to discuss how to meet the needs of journalists and members of the public. Dans mon allocution, j'ai encouragé autant les juges que les spécialistes en communication à fournir au public des renseignements qui soient pertinents, rédigés en langage clair et facile à trouver. Autrement dit, à adapter l'information au public qu'ils servent. L'un de mes exemples préférés à cet égard est la manière dont la Cour de justice du Nunavut émet ses gazouillis en anglais, en français et en ituktiktut. Je suis toujours heureux d'avoir l'occasion de rencontrer les diverses parties prenantes de notre système de justice, juges, juristes, société civile. Récemment, j'ai pris part à des activités de l'Association canadienne des juges des cours provinciales à Halifax, de l'Association du barreau canadien à Charlottetown, de la Fédération des ordres professionnels de juristes du Canada à Ottawa, de l'Association des juristes d'expression française à Canmore, en Alberta, d'étudiants pro bono du Canada à UBC, à Vancouver, de Jury Pop à Montréal, de la clinique juridique en droit social de l'Outaouais et d'Avocats sans frontières, depuis les dernières semaines seulement. Je sais que mes collègues sont aussi très impliqués. Ces rencontres nous permettent de mieux connaître les initiatives inspirantes et les préoccupations des divers intervenants sur le terrain, d'échanger et d'alimenter nos propres réflexions. I would now like to give you an update on the Action Committee on Court Operations. This is the group that I co-lead with Justice Minister David Lametti. We established the committee at the outset of the pandemic to find ways to keep courts open. Recently, our members decided to continue its work until at least the fall of 2024. We also updated the group's mandate and key principles. One of them relates to reconciliation with Indigenous peoples and how action is required to dismantle institutional barriers that have limited access to justice. I look forward to seeing how this work progresses over the next 18 months. I encourage you to read more on the website of the Office of Canada's Federal Judicial Commissioner. As chair of the National Judicial Institute, I can tell you that it continues to rise to the challenges of these times with world-class education that encompasses substantive law, skills, and social context. It is the reason why Canada's judges are the best trained judges in the world. Last year, the NJI delivered 79 programs across Canada for a total of 211 education days, which is 30 more than the pre-pandemic average. Highlights of some of the new in-person programs include an Indigenous law seminar on the territory of the Whitecap Dakota First Nation outside Saskatoon, and a Judging in Your First 5 Years family law course. In partnership with the Canadian Judicial Council, the NJI is also opening up more training spots for provincial and territorial judges. And as some of you may know, the NGI continues to offer training to judges and court administrators around the world. An investment in judicial education promotes a culture of judicial excellence. Mon travail comporte également un volet international. En qualité de juge en chef du Canada, j'accueille des délégations étrangères, d'autres tribunaux, et je participe à des échanges entre juges. Ce sont des expériences précieuses pour moi et mes collègues. Il y a très peu d'occasions de s'asseoir avec nos homologues internationaux et d'entendre parler des réalités de leurs tribunaux et de leur communauté, et de la façon dont ils traitent les questions juridiques émergentes. Au cours de la dernière année, nous avons notamment eu des échanges avec les cours suprêmes de l'Irlande, d'Israël, et participé au colloque judiciaire Asie-Pacifique en Nouvelle-Zélande. J'ai aussi eu des rencontres virtuelles avec mes homologues du Japon et de l'Afrique du Sud. Nos conversations ont porté notamment sur le droit comparé, la modernisation des tribunaux, l'indépendance judiciaire et la désinformation. Je prends également chaque année la parole devant un groupe de hauts commissaires et d'ambassadeurs nouvellement nommés au Canada, que nous accueillons à la Cour pour leur expliquer le rôle de la Cour au sein de notre système démocratique. Un sujet sur lequel je reviens constamment est celui du déclin de l'indépendance judiciaire dans de nombreuses régions du monde. Je rappelle que ce principe n'existe pas pour les juges, mais ultimement pour le public. Il est essentiel pour faire en sorte que les juges puissent trancher les questions de droit qui leur sont soumises sur la base des faits et du droit, à l'abri d'ingérences et d'influences indues. Même au Canada, il y a de la désinformation sur notre système juridique. Cela n'est pas toujours bien compris. Upon receiving the Nobel Prize in 2021, Filipina journalist Maria Ressa said, and I quote, "Without facts, you cannot have truth. Without truth, you cannot have trust. Without trust, you have no shared reality, no democracy, and it becomes impossible to deal with our world's existential problems: climate, coronavirus, the battle for truth." End of quote. Just like a free and independent press, there is no democracy without judicial independence. These are principles that all of us need to uphold, from reporters to politicians to lawyers and judges to members of the public. Thank you very much for your attention. Je suis maintenant prêt à prendre quelques-unes de vos questions.
Merci, juge en chef. Pour la période de questions, vous pouvez poser votre question évidemment dans la langue officielle de votre choix. Il y a beaucoup d'entre vous. Je vais tenter de respecter le principe de l'ordre d'arrivée autant que possible et de l'alternance français-anglais. So there's quite so many of you this morning. I know you have all questions. Please limit yourself to one question, one follow-up. If possible, short questions, short answers, so we can pass as many as possible. So first up, Tonda McCharles, Toronto Star.
Good morning, Chief
morning.
Justice. Can you talk about, I think a lot of us have questions about the Russell Brown case, and I'm curious as to your thoughts around how the closing of the case now upon his retirement meets the need for what you call transparency to restore trust in institutions like the court. That's an interest you've expressed that the court has and the public has. So can you speak to that?
Yeah, well, I share the concerns of the public for transparency, and I've been talking about that for years now. And of course, as you know, as chair of the Canadian Council and Chief Justice of Canada, I'm not involved in the disciplinary process, the judicial conduct process at the CJC. The reason is to keep my freedom of expression as Chief Justice of Canada, and also to avoid any conflict of interest. So any, questions relating to this judicial conduct regarding Justice Brown should be addressed to the Special Committee on Judicial Conduct of the CJC. But I'd like to mention something because, since I became Chief Justice in 2018, I realized that there was something to be corrected at the Judicial Conduct Committee. The judicial conduct process was, as I mentioned, was opaque. It was too long, too costly, and it was not possible for the public to have trust if they realized that they could not get the real issue, the reality. That's why I started to say and to ask for reforms of the judicial process conduct. And as I mentioned, after a few years, I was happy to see that government has decided to legislate on that issue, to be more transparent, less costly. It costs millions of dollars right now, according to the same process, which has not been amended yet. And it was, for me, it was scandalous and it had to be changed. So, but the government reacted. They filed S5 to start with in 2021. S5 died on the order, and then it became S3 through the Senate once again. And again, S3 was changed to C9, and C9 was presented and introduced at the House of Commons. C9 was adopted by the House of Commons, and it was sent to the Senate, and the Senate suggested a few amendments. Recently, the Justice Minister said that those amendments are not acceptable and will probably return the C9 to the Senate. So it's been kicking around Parliament for quite a few times, for quite a few years, I would say. It has to stop. This legislation has to be adopted. And I think that it would be in the best interest of the public, best interest of the judiciary, and in the best interest of transparency. That said, at the last meeting of the CJC in April, I asked the Committee on Judicial Conduct to look at their own regulations to see if it was not possible to make it more transparent. And I give you the example, for instance, when should a complaint be made public? When the wording of a decision should be made public? There's something opaque right now, and I'm not comfortable with that. And I asked the CJC, I asked the Committee on Judicial Conduct to look at it. And I think it would render the life of many people much easier, starting with the Chief Justices across the nation, to have something clearer, which could be understood by everybody, and that would improve the expectations also amongst the public. So all this question of judicial conduct needs to be looked at. I hope that C9 will be adopted as soon as possible. That's the first step to make sure that the process is more transparent. But also, there's some work, I think we can do better at the CJC. There's some work to be done to look at it and try to find ways to make it more transparent. I have reasons to believe that it will be done.
I mean, the lack of transparency that you've just described, I don't know if C9 necessarily fixes that, but can you speak to, like, it seems that there are two problems if both Russell Brown complained of a lengthy process that wasn't going to end until 2024, and now in closing the case, the public doesn't have an explanation of what really happened, and it's left to, Russell Brown to litigate it through his lawyers in the media. Where's the I think, justice and public interest in that?
Well, you will understand that I will not comment on Justice Brown's allegations or comments. It would not be appropriate for me to do that. And again, everything that is concerning the judicial conduct process should be addressed to the CJC and the Committee on Judicial Conduct. And I'm not involved in this process, so I think that there's work to be done. I think it's up to them to do the work, and I'll do my work.
Valérie Gamache, Radio-Canada.
J'aimerais vous entendre sur et les changements que vous proposez au Conseil de la magistrature et sur C9. En quoi, qu'est-ce qui concrètement va permettre d'apporter plus de transparence au processus?
En fait, la transparence, c'est une notion qui englobe beaucoup de choses. Alors, présentement, le processus de discipline judiciaire qui est en vigueur présentement, qui n'a pas encore été changé, entraîne le fait que, par exemple, dans le dossier de Giroir, on peut en parler, le dossier est fermé, là. Bien, pendant presque 10 ans, je répète, 10 ans, un juge qui a pratiquement pas siégé auparavant, qui fait l'objet d'une plainte disciplinaire sérieuse, ne siège pas, donc ne travaille pas, obtient son plein salaire, multiplie les procédures, parce que la manière avec laquelle le système fonctionne présentement, c'est qu'il y a des révisions judiciaires potentielles à chacune des étapes du processus. Je réalise que la révocation d'un juge au Canada, c'est une question très sérieuse. On ne peut pas révoquer des juges pour des raisons banales. C'est très sérieux. C'est la raison pour laquelle il faut avoir un processus sérieux également. Cela dit, il faut avoir un processus efficace. Et présentement, ce qui est arrivé dans le dossier de Giroir, par exemple, puis là, il y a un autre dossier qui est en jeu, qui est en chemin, qui est dans le même sens, c'est qu'il y a plusieurs procédures qui sont amorcées de façon inutile. Et tous les coûts, bien, c'est les justiciables qui payent ces coûts-là. Ça a coûté des millions de dollars, le dossier de Giroir. Et il a été, la conclusion du Conseil canadien de la magistrature, c'est la révocation de ce juge-là. Bien, il a démissionné juste avant que le Parlement soit saisi de la question de la révocation. Ça, c'est scandaleux. Parce que pendant 10 ans, il n'y a pas eu de juge qui siégeait. Pendant 10 ans, il y a eu quelqu'un qui a obtenu son plein salaire. Pendant 10 ans, par la suite, ça lui a permis d'avoir sa pension, pleine pension. C'est scandaleux. Et c'est la raison pour laquelle il faut que ça soit changé. C'est une question de transparence, ça aussi. De permettre aux gens de comprendre là, que s'il y a une plainte sérieuse, elle va être traitée de façon sérieuse, mais de façon efficace. Il faut avoir un régime de protection, à la fois pour protéger l'indépendance judiciaire. On ne peut pas révoquer un juge parce qu'on n'aime pas une de ses décisions. C'est fondamental à notre démocratie. Donc, c'est juste pour des motifs vraiment qui, par exemple, vont à l'encontre des principes d'éthique que nous avons adaptés l'année passée, que nous avons améliorés l'année passée. Alors, pour ces raisons-là, on va pouvoir, effectivement, à la fin de la journée, un juge sera redevable s'il a agi à l'encontre de ces principes d'éthique, mais il faut avoir un processus qui soit quand même rigoureux et qu'on ne permette pas des appels incidents, des révisions judiciaires multiples, simplement pour gagner du temps. Parce que ça mine la crédibilité du système dans l'esprit des citoyens.
Vous avez dit que la démission de Russell Brown n'a rien à voir avec le travail qu'il faisait à la Cour suprême, mais quel impact ça aura donc sur les décisions sur lesquelles il travaillait actuellement, le fait qu'il ait démissionné? Qu'est-ce qui se passe avec ces dossiers-là? Est-ce qu'on les reprend à zéro? Est-ce qu'on les poursuit où ils en sont rendus? Là?
On continue à rendre nos décisions, que ce soit à 5, 7 ou 9 juges. Alors, une décision de la Cour suprême, elle a la même force qu'elle soit rendue par 5 juges, 7 ou 9. Alors, il y a eu des précédents dans le passé. Et d'ailleurs, depuis les dernières années, depuis peut-être les 20 dernières années, la Cour a siégé plus souvent à 7 juges et à 5 juges qu'à 9 juges. 9 juges étant habituellement réservés dans les dossiers, notamment les renvois en matière constitutionnelle et les dossiers d'importance, puisqu'il est important d'avoir quand même un panel complet pour les dossiers les plus importants. Mais on continue à rendre des décisions à 7 ou à 5 et ça va continuer.
Christine Schmitz, Law 360 Canada.
Thanks for coming, Chief Justice, meeting us in our own forum. I'm returning to the judicial conduct aspect and how the Canadian Judicial Council operates. In the Brown matter, they've taken there's nothing to see here approach. They refuse to release the name of the complainant, any of the formal complaints, allegations, and most importantly, the review panel's reasons and recommendations that a formal inquiry is justified, because if the allegations are true, they're serious enough that they could lead to the judge's removal for misconduct. And I have to ask you, well, one, have you read the report? But how can the public have confidence that when the Canadian Judicial Council is refusing to disclose any information about what it learned investigating allegations that a judge of the highest court in the land was drunk and harassing women in a bar earlier this year? There was a lot of money spent, a lot of effort spent, 2.5 months, all at public expense, and we are told nothing. How can the public have confidence? As you said, confidence is based on transparency, and there's been none. What do you say to that?
I absolutely share your concerns. Absolutely share your concerns. And, the end result of this process is that I understand, and I'm not involved in the discipline process, but I understand that the last review panel had to decide whether the allegations were serious enough to eventually bring to the removal of the judge. That was not public, but the next step maybe would have been public. It's part of their own regulation, inside regulations of the Committee on Judicial Conduct. And that's the reason why, that's exactly the reason why I asked at the last meeting that they looked at it. And I'll give you an example of some help that could be drawn from this exercise. You know, when I received a complaint from CGC, I received a complaint at the same time as Justice Brown. Looked at it, called him immediately to have a discussion about what's in it. And we both agreed that it was, in the circumstances, the best course to adopt would be for him to stay on the side and leave the court, pending the resolution of this complaint. And then the question is, should I disclose the fact that there's a complaint against Justice Brown? According to the existing regulations, it's the CGC which decides when to disclose whether there is a complaint against a judge. So I was a bit taken, and that's why I said to my colleagues, and I said to the Judicial Conduct Committee, look at it, because I should not be in a position, like any other Chief Justice in other courts, to be necessarily submitted to a regulation that does not allow me to make it public. So this whole, and at the same time, there are so many unwarranted complaints against judges. You know that a big majority of complaints against judges are filed by persons that are not satisfied with the judgment. And most of them will be dismissed at the first examination. That's the majority of complaints. Very few complaints goes further and are very serious. So at the same time, you have to protect also the privacy and reputation of judges when frivolous complaints are made with social media and so on and so forth. So you have to appreciate that you have to navigate keeping in mind those principles. I think there's a way to do it. I think we could be better, and I hope that we will be better.
So as a follow-up, Chief Justice, are you not concerned that the council is suppressing a report, making a recommendation that the allegations should go to a formal inquiry? Are you not concerned that the judges who are supposed to be self-regulating and self-disciplining could look as though they're covering up alleged misconduct? And I should be, you know, just mention that Justice Brown has said the complaint is utterly spurious and false. However, one of the council's committees has sent it on to an inquiry. Are you worried that judges are going to lose credibility about investigating their own? I
don't think so. The alleged allegations, as you mentioned, could have brought a special inquiry, the setup of a special inquiry, which would have maybe eventually asked for the removal of the judge. The judge has resigned.
Was it on the condition that it would not, that the council would not disclose the report and the recommendation?
I don't know. I just, you know what? I received the letter of resignation, not by Justice Brown. I received it from the CGC at the same time as a note saying that the file was closed. I received that. So that's all I can say.
Toya Isri, Global News.
Hi, Chief Justice. So now that Mr. Brown has resigned, I mean, what does this mean for representation on the court? I mean, you're down, you know, a Western judge. So what should the Prime Minister consider when he's looking for a new appointment?
Well, that's up to him. I hope he'll, and I have reasons to believe that he will try his best to appoint a new judge as soon as possible. It is preferable to have a full panel. You mentioned a Western judge, of course, but we don't release decisions according to the, you know, whether it comes from the west, the east, or the north. The Supreme Court is the Supreme Court. The decision of the court is by the members of the court. And there's no decision that comes from the west or that comes from the east. So I'm very confident that we'll be able to work at 8 judges, and like we did for the last couple of months, having a panel of 7 and panel of 5 for other cases. And so I'm looking forward to this new appointment and working with this new person as soon as possible. Our sessions will start in October. I would hope that this new judge, this new colleague, will be appointed by then, and I'm looking forward to that.
This was asked in French, but just in English. How did Mr. Brown's absence affect the business of the court? I know you said, you can still make decisions with 5 or 7, but he was still, overseeing certain cases.
When you look at the decisions we released since the month of February, look at it, and you will see that those are strong, well-reasoned reasons, I believe, and well-reasoned decisions, and we will continue to do that.
Hélène Buzetti, Coop de l'Info.
Oui, bonjour, M. Wagner. J'en comprends d'une réponse que vous avez donnée à ma collègue tout à l'heure que ce n'est pas vous qui avez demandé la démission du juge Brown. Je voulais juste clarifier ça.
Non.
Donc, vous m'excuserez, je ne suis pas tellement familière avec le projet de loi C9, c'est le genre de projet de loi assez technique qu'on ne consulte pas vraiment. Pourriez-vous nous expliquer en quoi, si ce projet de loi avait été en place, ça aurait modifié la façon dont le cas Brown a été géré ici?
Bien, ça n'aurait peut-être pas modifié le cas du juge Brown parce qu'on est au stade préliminaire présentement. Le projet C9, c'est pour reformuler, c'est un amendement à la loi sur les juges qui reformule le processus de discipline des juges. Et essentiellement, c'est prévoit qu'au lieu d'avoir différentes étapes dans le processus de décision, qu'on limite le nombre d'étapes, qu'on empêche la révision judiciaire. En d'autres mots, s'il y a une décision, par exemple, du panel de révision qui est rendu, le juge ne pourrait pas aller en révision judiciaire en Cour fédérale, par exemple, pour renverser cette décision-là. Alors, il y a un processus qui doit suivre pour éviter les délais indus, mais quand même avec un processus d'appel, avec une finalité d'un recours devant la Cour suprême du Canada sur permission. Et donc, ça raccourcit le processus, ça le rend moins coûteux et ça permet aux juges de savoir à quoi s'en tenir rapidement. Puis ça permet au public, aux citoyens, je pense en tout cas, d'avoir foi au processus beaucoup plus transparent puis que ça ne coûterait pas des millions comme dans le passé. Et ça va éviter des injustices également de gens, ça se peut, des gens comme le dossier que j'ai énoncé tantôt, qui vont utiliser les délais uniquement pour pouvoir éventuellement avoir un droit à une pension. Alors, pour éviter les excès, les abus. C'est pour ça que C9 était nécessaire. C'est pour ça que je le demande depuis 2018.
De l'importance de la transparence, de la confiance dans notre système de justice. Je me demandais si vous aviez des commentaires à faire sur ce à quoi on assiste ces jours-ci depuis quelques semaines, en fait, les déclarations politiciennes concernant Paul Bernardo, qu'on a appelé, excusez mon langage, fils de pute, monstre, ordure. En tant que juge, comment percevez-vous ces commentaires? Sont-ils appropriés et est-ce que ça a un impact sur la perception de l'indépendance judiciaire aussi?
Bien, je pense, je ne commenterai pas évidemment ce cas-là en particulier, là, mais je pense que ça fait partie de l'image de notre système de justice d'avoir des gens qui s'expriment convenablement. Alors, les abus de langage, là, que ce soit à l'intérieur de la Cour ou à l'extérieur de la Cour, par des personnes qui sont impliquées dans le système de justice, ce n'est pas de nature à accroître la confiance du public. Je pense que les gens s'attendent à ce que les gens utilisent un langage approprié, modéré, dans le système de justice. Alors, je ne peux pas aller tellement plus loin que ça pour commenter la situation que vous me mentionnez, là, mais pour moi, c'est important. Dans la mesure où, effectivement, les juges sont concernés, parce que c'est ça dont je m'occupe, le système de justice en général, que les intervenants dans le système de justice emploient toujours et agissent de façon raisonnable pour effectivement permettre aux citoyens de croire et d'apprécier la crédibilité de nos institutions, de ceux qui les occupent également, puis qui sont appelés à rendre des jugements, des décisions qui vont affecter leur quotidien. Je pense que ça commence par là.
Ian Bailey, Globener.
You say the allegations against Justice Brown had nothing to do with the work of the court, but of course they happened when he was a justice of the Supreme Court of Canada. What do you say to Canadians about this? How does this reflect on the court? I mean, Canadians looking on at this, at these kind of allegations against one of the highest justices in the country?
Well, it's unfortunate, of course, but I believe that in as much as it concerned, in this specific case concerns one judge and one behavior outside of the courtroom, I don't think that the people will have a bad opinion of the Supreme Court following this incident. I think that they should be comforted by the fact that in Canada we have ethical principles, that the CJC made sure 2 years ago to look at those ethical principles so that it would be relevant in 2023. I think that people should be happy to learn that we take those questions seriously, the ethics of our judges, and that we have a process, and we have ideally a more open process in the future. So I think that people, knowing that, I think it's a source of comfort in a way, compared to maybe other society where there's no ethical principles governing judges, there's no judicial conduct governing the conduct of judges. So when you compare, I mean, I think that people will realize that we're privileged in Canada to have that type of process and the notion of ethical principles.
If something like this happened again, would you seek to release the information on the matter more quickly? There's some concerns, obviously.
I hope it will never happen again.
But
and if a complaint is filed again against the judge, it will be up to the Canadian Judicial Council and the Judicial Conduct Committee to take care of it, not me.
Ashley Burke, CBC.
Good morning, Chief Justice.
Good morning.
What do you think of the message that it sends to the public that if you are a Supreme Court justice in this country and if you are accused of misconduct allegations that you can retire and there is no investigator's report, the process ends? Are you comfortable with that?
Well, I'm not comfortable with any complaints against any judges. One complaint is one too many. It should never happen. But that's reality. It happens. What I'm saying is that we're lucky in this country to have some institutions to take care of those complaints. And just like in any other organizations, there will be problems. But I take some pride in the fact that in Canada, judges, federal judges, and provincial judges are governed by ethical principles. And if they don't follow it, if they make an error or mistake, serious enough, there is a process, and there is a way to deal with that. And I think that the Canadian citizens should appreciate that.
Would Bill C9 address this so that, or make any changes so that if you do retire, the complaint process doesn't just stop? And if not, is that something that you want to see the CJC change so that an investigation, they still have jurisdiction over an investigation if someone retires? Well,
I think C9 has several aspects to it. There are provisions dealing with the funding of the contestation before the court. In other words, to what extent a judge could have his legal fees paid by the state. There are some provisions also regarding the pension, to what extent if there is contestation that will have an impact on the level of pension that could be awarded to the judge. So there are several provisions that will deal with and whose objective is to render the process more fair and just. So there's not only the question of loss of appeal rights before the federal court, for instance. There are other provisions which will, I think, render the process more fair and transparent.
Jim Brownskill, Canadian Press.
Good morning. I think what my colleague Ashley was getting at, would it be wise to change the process so that we're not left with this lack of closure that we have, many see in the Brown case, that there would be a way to finish the process and not allow a judge to leave before it is complete? Is that something that should be either done in the law or through the procedures of the CJC?
Well, the process is there, and it's finished because the judge resigned. So there's no matter to deal with anymore. So if your question is to determine to what extent there's an end to the process, there is an end to the process. He resigned. So the difference is that it did not go further, and it did not involve a public inquiry, and it did not involve disclosure of all the evidence, which in any event you probably already have from what I read in the papers. So that's the main difference. So, but there is a closure. There is a closure. He resigned.
You spoke earlier about judicial vacancies. Could you expand on the effects this has for the system across the country and for the Supreme Court of Canada?
It has major effects in every province of this country. I'll give you just an example. The Associate Chief Justice of the Superior Court in Quebec, the position is vacant since March 2022. Now, the district of Montreal, the Superior Court in Montreal, is probably one of the busiest districts in Canada. It's been 16 months now that the position is vacant. So what the judges will do? Well, they try their best. They will try their best to accommodate, but there are some consequences. In Alberta, for instance, there are 22 cases over 30 months, and you know what that means, eh? That means potential stay of proceedings in criminal matters, because there's no judges available. That's not the only reason. There's a lack of funding by provincial government, lack of personnel, cases are postponed, hearings are postponed because there's no clerk available in the courthouse. That's the reality as well. But if the government would at least appoint judges where there is vacant positions, that would help. That would be a big, very good remedy, at least on the short term. And there's no surprise. When a judge retires, he gives usually 6 months delay. During 6 months, the government know that there will be an appointment to be made. And there are candidates available in every province. So there's no reason why those vacations could not be filled. And in other provinces, you know, as I mentioned, they work with 15% less of judges. And what does that mean in some instances? And that's a reality as well. Other judges will take over from more tasks because there's a lack of judges. That has created problems of mental health issues in some provinces, serious. And also in some provinces, judges are called to decide, to make decisions, which case will proceed. In other words, you know, in criminal cases, that one should proceed before the other one because of the Jordan delay, there might be a stay of proceedings. We should not ask judges to make those decisions. And Jordan is not the cause. The judicial system should accommodate Jordan. We should have the means, the judges, the financial means, the funding to accommodate the functioning of the court within the delay of Jordan. So I don't accept that Jordan is the cause. I think that we have to correct the system by providing more funding on the provincial level, of course. That's part of the provincial obligation. And insofar as the federal government, at least, appoint judges when there are 80 vacant positions. So they are important situation. I wrote to the Prime Minister because at the last meeting of the CJC, all the Chief Justices, most of our conversations dealt with this issue. It's so important that the Chief Justice are looking for solutions. And we discussed that, and it was decided that I would write to the Prime Minister and to alert him of the serious consequences of these lack of appointments in due time that could be resolved easily, and with consequences that we know. And that's why I wrote to the Prime Minister and to alert about this condition. And I'm pretty sure that he takes this situation seriously because he called me back. And he said, and I explained to him why I wrote that letter, why and what were the consequences of not appointing judges when there are vacant positions. And he said to me that he would provide his best effort to appoint the best candidates, of course, and to try to correct the situation. It was a short conversation, but I take it that if the Prime Minister took the time to call me, it's because he took the problem seriously. And so that was my responsibility. So now we'll wait and we'll see. So stay tuned.
Dale Smith, freelance.
Hi. Regarding the vacancy now in the court, are there any particular skill gaps that you would like to see the Prime Minister take into account? I mean, we haven't had a criminal specialist since Moldaver retired. What other skills gaps do we have now that Brown is retired?
No, the choice of the Supreme Court justice, it belongs to the Prime Minister upon consultation, I understand. And so it's not for me to decide, which profile. I already said that, and so far as I'm concerned, I think that every justice of the Supreme Court should be bilingual. And I would also, I would love to see that diversity be maintained on the bench as well. I think we're doing well. We're doing well at the Supreme Court, but we're doing well as well throughout the country. Almost 50% of all judges, federal judges, are women. That's a big step, and I'm very happy to see that. And also in the minority groups, LGBTQ, racialized groups as well. We have more appointments, so we're going in the right direction. That's a very good and positive step. So we have to keep it. We have to keep it. So I don't have any advice to the Prime Minister, simply to choose the best candidate.
And just returning to the Committee on Judicial Affairs, I would just like an opinion from you on the length of which these investigations are taking, and the fact that a justice of the Supreme Court felt it was easier on the court to retire and appoint someone new in less time than it would take for that process to carry out.
But I cannot comment on those comments. But I can tell you that insofar as the process is concerned, I'm not involved. I don't know how it works, really, and why it takes that amount of time. But the only thing I ask, and I'm pretty sure that we'll get some positive answers, is that the CJC and the Judicial Conduct Committee looked at the way they are working and the regulations, and to come up with more transparent solutions.
Joyce Napier, CTV News.
Hello, Chief Justice.
Yes.
About the vacancies, from what I understand from your answer, is now judges sitting on federal courts are doing like a triage system, a little bit like our healthcare system. We asked the Justice Minister on his way to Cabinet today, and he said that he's working on replacing, on the backlog, but he's concerned that some cases may get thrown out because of the Jordan Principle. Do you know how many cases now, because of this backlog, are getting thrown out, or in what provinces?
I don't have the statistic for every province, but I can only rely on my letter to the Prime Minister when I mentioned that in Alberta, 22% of the active criminal cases exceed the 30 months delay of Jordan. And 91% of those cases, though, 91% of those 22% involve serious and violent crimes. So that gives you an idea. That's for Alberta. I suspect that the situation is the same in every other province. I can appreciate, and I'm sure that the Justice Minister is doing his best. And we have a very good relation of trust between the Chief Justices in Canada and the Minister of Justice. But I think that I think that one remedy, one part of the remedy would be to make sure that appointments are made in a timely fashion. That will help a lot. And as I mentioned to you, I believe that Jordan should not be looked at the cause of those problems, but we should adapt to it, because Jordan was rendered because the court realized that it was taking too many years for a criminal case to come to trial. You had case for 5, 6 years. How can you ask a witness or a victim to wait for 6, 7, 8 years before going to trial? It didn't make any sense. Now, that said, you will recall that in Jordan, I was in dissent. It was a 5-4 decision. I thought it was a big price to pay. But when you look at it a couple of years after, I think it was right to do that. That's the law. A society like us, governed by the rule of law, with a strong democracy and a charter of rights, should be able to make sure that a criminal trial comes to trial within a reasonable delay. So I think that our society has to adapt to that, not the contrary, not the other way around. So we have to make sure that the justice system can work in considering Jordan and the delays to bring a case to trial, not the other way around.
So you asked you wrote a letter to the Prime Minister, the Ontario Bar wrote a letter to the Prime Minister. Judges give 6 months notice. That's 6 months notice, not the 2-week notice in every other business. So what is the government telling you? How difficult is it to fill those vacancies, and why aren't they doing it?
Yeah, one more thing is that the CBA sent a letter to the Prime Minister about the same issue. So I'm not the only one, thankfully. But I don't know exactly what's the problem. Honestly, I don't know what's the problem. And one thing for sure is that at least those judges who retire will give usually 6 months delay. There are vacant positions, as I mentioned, about Associate Chief Justice for more than a year. Manitoba was filled recently, but it took many months. There are other positions as well that are not filled. So what's the reason? I don't know. But one thing for sure, it's a big concern. And now the Prime Minister is aware of that. And I'm confident that he will take the steps necessary to make sure that the solutions be provided.
Chris Nardi, National Post.
Good morning, Chief Justice. Just out of curiosity, do you think there's a certain level of irony to the fact that a judge who was on the panel who put out the Jordan ruling has now resigned in part due to judicial delays, basically?
No, that's one way to look at it. I never thought about that. I don't see any irony in that. It's coincidence.
Does it speak kind of to the state, kind of on that question, does it speak to the state of delays across the country?
Well, we should not mix things. The delays in the courts, whether it be in civil or criminal or commercial, that's one thing. The delays involved in the judicial conduct process is something else. So when you were talking about Jordan, we're talking about the delays regarding criminal cases that should take less than 30 months in superior courts. The other delay, it regards the CGC and the judicial conduct process. And with the C9 adopted, there will be very short delays so that the claim will be, or the complaint will be dealt with in a very short delay. So that's two different things.
And the other question I had is, more broadly about the work of the court. So I was reading an analysis not too long ago that a number of lawyers did about the number of applications that the court has accepted over the last years. And they noted that in 2022 was by far the lowest amount of applications that you've granted leave, 24. But it was also amongst the lowest proportion of cases, applications that were granted leave at about just over 5%. And there was a concern there that if there's a dwindling number of applications that are granted, that, important, crucial judicial questions will go unanswered. How do you respond to that? Is there really, are you choosing to accept less leaves? Is it a conscientious decision? And what do you say of those who are concerned that the Supreme Court is just hearing less cases?
That's a very good question. There are several reasons. First of all, because of the pandemic, of course, there were fewer judgments from the lower courts, the trial courts, fewer decisions of the appeal courts. So therefore, less applications for leave to appeal before the Supreme Court. That's one of the big reasons why we went to, I think, from 550 to 400 something leave applications. So there was a big impact of the pandemic on the leave application. The second thing is you have to know that about 25%, depending on the year, 25% of all leave applications are filed by self-represented litigant. So that could have an influence also on the number of applications every year. We did not change our criteria. The court will grant applications for leave to appeal if there's a legal issue of public importance, when there's a controversy amongst the appeal court throughout the country. So those are the cases where the court will decide to hear cases, the cases. So there were no changes of our criteria. And so we will continue to follow the same rule about the leave applications.
Daniel Leblanc de Radio-Canada. Probablement la dernière série de questions. Je reconnais qu'il y a deux autres journalistes dans la salle, donc à moins que Monsieur le juge en chef vous acceptez de rester un tout petit peu plus longtemps, on va terminer avec Monsieur Leblanc.
Bonjour.
Bonjour.
Au sujet encore des nominations à la magistrature, on s'entend que vous n'écrivez pas une lettre au premier ministre de façon... Vous ne prenez pas ça à la légère. Vous avez fait des démarches aussi avant. Vous aviez rencontré le ministre de la Justice à ce sujet-là. Où est-ce que le processus bloque? Vous semblez écrire dans votre lettre qu'à la justice, on fait tout ce qu'on peut pour que ça aille plus vite. Êtes-vous d'avis que c'est peut-être au cabinet du premier ministre qu'il y a des vérifications supplémentaires, que le processus pourrait aussi bloquer? Et est-ce que vous avez fait part de ça à M. Trudeau?
Bien, ce que j'ai fait part au premier ministre, c'est de l'état de la situation dans les différentes provinces et de l'impact de l'absence, de l'omission de nommer des juges dans un temps raisonnable. C'est ça que je lui ai dit, pour qu'il réalise qu'on ne peut pas continuer comme ça, parce que là, ça avait un impact sur, et potentiellement sur la démocratie. Parce que si ça amène, par exemple, des arrêts de procédure dans les dossiers de violence, par exemple, l'agression sexuelle, la violence conjugale, les meurtres, bien, les gens risquent de perdre confiance dans le système de justice. Alors, il faut éviter ça, d'une part. Deuxièmement, c'est pas... ça se fait de dénomination dans un temps raisonnable. Alors, je voulais simplement lui souligner que c'est possible de le faire. Alors, c'est quoi le problème? Je ne le sais pas. Vous pourriez peut-être lui demander. Ce que j'ai su, cependant, et c'est tout ce que j'avais à faire, moi, pour représenter les juges en chef et m'assurer que les représentations étaient faites, c'est qu'il fallait nommer les gens, des juges, quand les positions étaient vacantes. Et c'est une question de démocratie en bout de ligne, hein, parce que si les gens perdent foi dans leur institution, en bout de ligne, ça va avoir un impact sur la nature et la force de la démocratie. Moi, je suis pas mal sûr que le premier ministre est sensible à ça. Il devrait l'être. Puis, j'ai bon espoir que la situation va être corrigée, mais on verra.
Là, on parle souvent du criminel, mais en tout cas, la juge en chef de la Cour supérieure du Québec parlait aussi des enjeux au niveau civil. Qu'est-ce que ça passe peut-être un petit peu plus inaperçu qu'un criminel qui est rendu, dont la cause ne se rend pas jusqu'au bout, mais au niveau civil, quelles sont vos préoccupations?
Bien, c'est des vases communicants. Hein? Alors, il y a un certain nombre de juges disponibles dans un district judiciaire. Alors, il y a des causes criminelles, des causes civiles, des causes commerciales. Et ce que j'ai compris, c'est que on va mettre l'accent sur les causes criminelles à cause des enjeux sur la liberté des gens, mais également sur l'impact sur la société au niveau de la sécurité des gens. Et en faisant ça, bien, on va privilégier des causes criminelles aux dépens de certaines causes civiles qui vont prendre encore plus de temps à procéder devant les tribunaux. Puis même à l'intérieur des causes criminelles, je peux vous le dire, là, il y a un choix qui se fait. On parlait d'une espèce de sélection comme dans les hôpitaux. Là. C'est exactement ça qui se passe. Là. Et moi, je trouve ça terrible. Moi, je trouve ça inacceptable. Où on va choisir tel dossier par rapport à un autre, alors qu'on parle de dossiers de matière criminelle qui impliquent la sécurité, la protection du public. Ça, il faut éviter ça. Alors, c'est le jeu des vases communicants avec une population restreinte de juges. Puis là, ils essayent de manœuvrer avec ce qu'ils ont, avec les moyens du bord. Ça, c'est sans s'ajouter, ça, c'est quand il manque de juges. Ça, c'est sans comprendre le fait qu'en raison du manque de personnel dans plusieurs provinces canadiennes, je le sais plus particulièrement au Québec, il y a d'autres raisons aussi où effectivement il y a des retards. Mais alors, au moins corrigeons ce qu'on peut corriger, là, en nommant au moins les postes qui sont vacants. Les budgets sont déjà approuvés. Alors qu'on nomme.
On m'indique que c'est malheureusement tout le temps est parti pour cette conférence de presse, même si je sais qu'il y avait d'autres questions dans la salle. Merci, juge en chef. Et,
merci à vous.
That puts an end to this press conference. Merci.
Bonne fin de journée.